Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Kidnapping Defense Lawyer in Chicago, Illinois. If you are facing kidnapping charges in Chicago, Illinois, you are dealing with more than just a legal issue. You are facing allegations that can impact your freedom, your reputation, and your future. Kidnapping accusations are taken extremely seriously in Cook County courts, where prosecutors often pursue these cases aggressively. These charges can arise from situations that are not always as clear-cut as they seem, including disputes, misunderstandings, or conflicting accounts of events. Regardless of the circumstances, the stakes are high. A kidnapping conviction can result in felony penalties, including significant prison time and a permanent criminal record. At Combs Waterkotte, our Chicago kidnapping defense attorneys understand how these cases are investigated and prosecuted, and how to challenge them effectively. We act quickly to protect your rights, evaluate the evidence, and build a defense strategy tailored to your situation. Call 3125-HELP or contact us online today to schedule a free, confidential consultation with an experienced kidnapping lawyer in Chicago. Kidnapping Lawyer in Chicago and Cook County, Illinois. Being accused of kidnapping in Chicago or anywhere in Cook County is an extremely serious matter. Even before a case is resolved, the allegation alone can impact your reputation, your employment, and your future. You need a Chicago kidnapping defense lawyer on your side right away. A conviction can carry significant prison time and long-term consequences that follow you for life. Under Illinois law, kidnapping charges can arise from situations that are not always what people expect. In some cases, what began as a misunderstanding, dispute, or attempt to help someone can quickly turn into a criminal allegation. At Combs Waterkotte, we defend individuals throughout Chicago and Cook County who are accused of kidnapping and related offenses. We understand how prosecutors build these cases and how to challenge them effectively. Our goal is to protect your rights, your freedom, and your future from the very beginning. Kidnapping laws in Illinois. Kidnapping in Illinois is defined under 720 ILCS 5/10-1. A person may be charged with kidnapping if they knowingly, secretly confine another person against their will, carry or move a person from one place to another by force or threat of force, deceive or entice someone to go somewhere against their will, confine a person without legal authority. Unlike what many people assume, kidnapping does not always require prolonged restraint or long-distance movement. Even a short movement or brief confinement, under certain circumstances, can lead to charges. It is important to note that aggravated kidnapping is charged under a separate statute, 720 ILCS 5/10-2, and involves additional factors such as ransom, harm, or use of a weapon. This page focuses specifically on standard kidnapping charges. Penalties for kidnapping in Chicago. Kidnapping is typically charged as a Class II felony in Illinois. A conviction may result in 3 to 7 years in prison, extended term sentencing in certain cases, fines and court costs, a permanent felony record. While standard kidnapping charges carry serious penalties, the consequences can become even more severe depending on the circumstances and any prior criminal history. Beyond criminal penalties, a conviction can affect your employment opportunities, housing options, and personal reputation for years to come. How kidnapping cases are built in Chicago and Cook County. Kidnapping cases often rely heavily on witness statements, alleged victim testimony, and circumstantial evidence. In many cases, there is limited physical evidence, making credibility a central issue. Prosecutors may rely on statements from the alleged victim, witness accounts, text messages or digital communications, surveillance footage, police reports, and interviews. However, these cases are not always straightforward. Disputes, misunderstandings, or conflicting versions of events can create significant weaknesses in the prosecution's case. What to do if you are accused of kidnapping in Chicago? If you are under investigation or have been accused of kidnapping in Chicago or Cook County, what you do next is critical. These cases can escalate quickly, and early decisions often shape how the case develops. Taking the right steps immediately can protect your rights and put you in a stronger position moving forward. Step 1. Do not speak to law enforcement without a lawyer. Investigators may approach you claiming they just want your side of the story, but their goal is to gather evidence. Even statements you believe are harmless can be misinterpreted or used against you. You have the right to remain silent under the Fifth Amendment. Use it. Politely decline to answer questions and clearly request an attorney before any discussion. Step 2. Avoid contact with the alleged victim. Do not attempt to explain, apologize, or resolve the situation directly. Any communication, calls, texts, or messages through third parties can be used as evidence. In some cases, it may also violate no-contact orders or lead to additional charges. Let your attorney handle all communication related to the case. Step 3. Contact a defense attorney immediately. Early legal intervention can make a significant difference in kidnapping cases. An experienced defense attorney can step in quickly, protect your rights during the investigation, and in some cases, influence whether charges are filed at all. The sooner you have legal guidance, the more options you may have. Step 4. Preserve all potential evidence. Kidnapping cases often rely heavily on conflicting statements and timelines. Save all text messages, emails, call logs, social media communications, and location data that may support your version of events. Do not delete anything, even if it seems unimportant. Digital evidence can play a critical role in your defense. Step 5. Document what you remember as soon as possible. Write down everything you can recall about the situation as soon as possible. Include where you were, who was involved, what was said, and how events unfolded. Small details can become important later, especially when challenging inconsistencies in the prosecution's case. Step 6. Do not discuss the allegation with others. Conversations with friends, family, or co-workers are not protected. Prosecutors can use statements you make casually as evidence. Avoid posting or messaging about the situation online. The safest approach is to discuss your case only with your attorney. Step 7. Follow all court or bond conditions. Carefully. If you have been arrested or released, you may be subject to strict conditions, including no-contact orders or travel restrictions. Violating these conditions, even unintentionally, can result in additional charges or immediate detention. Make sure you fully understand and comply with all requirements. The key is simple. Say less, preserve everything, and involve a lawyer as early as possible. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.